there was time to digest prior to the hearing date. And I believe I received something from my learned friend about 10 minutes ago. At one point, I was trying to hold on to try to keep the date. And in fact, yesterday, day before yesterday, I did ask my friend or try to get some indication of what she would be relying on. And I don't, but what she gave me or the point that she was making there, I don't actually see that in the submissions. And so the material that I see on the face of the submissions, which I haven't really actually had a chance to sit and read, isn't exactly what I was expecting. So.
Anything else?
That is it in a nutshell, Jamari. I do apologize for any inconvenience to the court, but I would observe that the reality is that on my end, I would have been in a position to proceed had I received the submissions of my learned friend.
From counsel?
Yes, good morning, my lady. I don't oppose Ms. Christopher's request or application for an adjournment, my lady. I do accept that she did in September, late September, send me some what I understood to be draft submissions, my lady. Given our busy schedules, and that's certainly not an excuse, it was very difficult to actually have an opportunity, as you know, Ms. Christopher's, I wouldn't call her long-winded, but there were rather lengthy submissions to have for the two of us to get to one place to sit down and have a discussion. As far as the submissions, my lady, which
what did you understand to be the point of you having received those submissions in draft?
My lady, there was a part, from what I understand, because I didn't attend the hearing on the 14th, someone held for me. I was not made aware, and that's not an excuse, my lady, that there had been an order that there should be some sort of agreement in respect of a certain portion of, I believe, the transcript or of some reporting. That was never communicated to me, my lady.
Okay,
and it was
outside
only
of the transcripts, you received what you understood to be draft
yes
from Ms. Christopher.
Yes, my lady.
And you also understood that there was a 2-week period within which you would have been expected to respond to those submissions with your own submissions had they been filed in accordance with the order. And you
Yes, my lady.
appreciated that you were not able, or you did not in the end, file anything in response within a 2-week period.
Yes.
Did it not seem to you incumbent also on you to give notice to the court?
My lady, in terms of, I did not, I did write to the court in February, formally.
Okay.
And I think
Dated
I
your
wrote,
letter or your email correspondence.
probably about the 26th.
Sorry, is there someone that's speaking? I don't know who that person is, but excuse me. Whoever has termed themselves high grade, please put your audio. Thank you. Mute your audio. What's the date of the correspondence?
I believe, my lady, I'm looking here, I think on the 26th of February, I wrote in to the court.
All right, that may not, let me just double check to see if that's on the file. It's not on the file. What does the correspondence say?
That the directions hearing held on the 14th, that the respondent was to file submissions by the 25th, after having had receipt of the appellant submissions, which were due to be filed, my lady, on the 11th. And we write to advise that we have not yet received those submissions. And in the circumstances, we were unable to comply with the court's order to file submissions. And there would be a delay. And that was on the 26th, my lady, of February.
Can you forward that email correspondence and for my attention, please? I want to make a note
Yes.
of this.
So
Thank you.
I would send it to you directly, my lady.
No, you can send it to the court, but ask that this email be
Yes.
forwarded directly onto me from court staff. Thank you.
Yes. And my lady, I wrote again in May as well.
What was the effect of your correspondence in May?
That correspondence was due to the fact that the matter had been listed in May for, I believe, Friday, the 28th, which was a public holiday.
Mhm.
And the inquiry was whether or not the matter was to be administratively delisted in the circumstances.
What does that have to do with your, I'm not looking for a full chronology.
No, my lady, that was the crux of it. And then I further went on to say that I had yet to receive submissions as well. So I still had not been in a position to comply.
All right. So you've made complaints or you've at least put the court on notice that you've not received any submissions.
Yes.
But when you did receive them in September, on the 16th of September, you did not write to the court thereafter. Is that it looks like it's frozen. Okay.
No, my lady, I don't believe that I did.
All right. And you've now filed submissions and served
I
them on
I
this-
did, my lady. I worked on them and I had them, I believe they were filed this morning with the court and also sent electronically. The hard copy should be with the court. And I believe my learned friend has now received the hard copy of those submissions.
And the request is for a one-day fixture. This is set for the full day. It's thought between the two of you that this will take an entire day. Is that correct?
My lady, that was not my understanding. I only realized it when I saw it in my diary that it was a one-day fixture. I don't know if that's Ms. Christopher's position.
Ms. Christopher?
I would think it isn't necessarily a whole day, but it would be a morning.
Okay. I usually address non-compliance with directions in my judgment, as opposed to in the form of some sort of a scolding to counsel in the hearing. It's obviously a source of frustration for me when directions are not complied with and there is no notice to the court. I think that there is much scope for understanding by the court when counsel are unable to operate within what might be the original directions. But what is always requested is the courtesy of some notice to the court so that fixtures like today are not lost. This might have been a fixture that would have been attributed to another matter. It's a loss of a court day, and it is truly frustrating and disappointing, to be frank about it, but there we are. So let's look for another date. I had in mind the 4th of March, which I think is a Friday. I'm just going to check the court calendar again. Have a look at that date while I look, please. Friday, 4th of March available to council?
Milady, yesterday at the Supreme Court mentions, Madam Justice Simmons fixed the matter of John Seaman, which involves, acts of indecency on a child, on the 2nd, to begin on the 2nd. And she expected that that trial would last for 10 days. So it's slated to begin on the 2nd of March and would continue, for 10 days thereafter. I'm actually lead counsel in that matter, my lady.
Can you get another council not take over from you in this matter?
I do have a junior, so I can make arrangements so that she can, I suppose we would get through much of the evidence. Mr. Richardson is on the other side, and I do know that he's the type of counsel who likes to agree and not waste time.
So the bottom line would be yes, I can put it in for the 4th of March.
Yes, my lady.
Okay, thank you, Ms. Christopher.
Yes, my lady.
All right, okay. So I'll set this matter done, adjourned to Friday, 4th of March. I'm gonna set it for 10 a.m. because Fridays are usually a busy day in the civil court. So in case I have any 9:30 matters, I'll set this down for 10. All right. There's no reason why that fixture would be further adjourned to my mind. In terms of the transcripts, what is the position? What's the current position?
There was only a small piece
Right.
that I made an adjustment to. In point of fact, that's something I've been trying to resolve since the very first appearance. I'm taking from the fact I haven't heard any objection from my learned friend either with respect to the draft or the final about the very small adjustment to the transcript that I would suggest should exist. And that was the overhearing of a denial by the appellant. But that wasn't put on the transcript. That's something, of course, that Ms. Dean can speak to.
Right.
Yes, my lady. That's fine. My lady, I should just the date that you've just given me, the 4th of March. I've just been interrupted. I don't know if my office is listening in. I'm being told that I don't have a junior in that matter on the 4th of March.
No, I was asking whether or not there's another counsel that could appear in this matter.
Oh, in this, well, I suppose well, I'd hate to put, the submissions are
My
done.
calendar is not an easy one
Yes.
to maneuver. It
I
really
appreciate
isn't.
that,
When I
Marie.
lose a fixture, you go,
Yes.
it really does cost months, literally
Mhm.
months. I'm not available in January. I'm not available in February, and March was tight.
Mhm.
It's not an easy thing for this court, I have to say, to just find fixtures for matters that were already slated to have been disposed of.
I crave your indulgence, my lady. If you just grant me 5 minutes, I can just go and confirm whether or not another counsel can actually do the appeal. The submissions have been finished.
Yes, okay.
I'm
gonna
grateful.
turn
Thank
my
you.
video off and we'll set it done. Actually, no, I will turn my video off, but please, can you hurry? Because I have a 10:30.
Yes, I will, my
mention that
lady.
I also want to get to. Thank you.
Yes.
All right. Yes.
Yes, my lady. That matter's fine. Someone else will do the appeal.
Thank you very much. All right. And Mr. Bleboda is on bail pending appeal. Sorry, Ms. Crispy, you're on mute.
Yes, he is, my lady.
All right. So bail extended. And there was a stay imposed against the magistrate's court proceedings pending
Correct, my lady.
these appeal proceedings.
Mhm.
Right. All right, unless you are informed otherwise, the 4th of March hearing will proceed by Zoom in the same platform, okay?
Yes, my lady.
All right. Mr. Bleboda, your bail is extended. You are expected to return on the 4th of March in this court via this platform, the Zoom platform. But you're also expected to be contactable if we need to administratively delist or to change the hearing date for whatever reason. So make sure that there is no difficulty that your counsel has in making contact with you so that you appear before the court when required to do so, because the court considers that in corresponding with Ms. Christopher, it has successfully reached you. Okay? All right. Thank you very much. And a good Christmas to everyone.
And to you, my
Thank you
lady.
very much.
And to you. Thank you, my lady.